Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law, and you can find us on wesncc.com and all social media platforms. Now, today is a very good topic. We are talking about bail. Are bail laws enough to solve crime? Now, we would have seen a lot of time, or actually in recent time, there has been much talk about amending the Bail Act to deny bail for particular offences as a result of a rise in crime from the government and members of the public. Now, I'll just go through a little history. On the 7th of May 2019, the Attorney General and Minister of Legal Affairs, the Honorable Faris Al-Rawi, introduced the Bail Amendment Act 2019, which sought to amend the Bail Act to deny bail for a period of 120 days to a person who is charged with a list of particular offences such as violent offences, sexual offences, robbery, possession of narcotics. Further, the highlight of the amendment also sought to deny bail for a period of 120 days to a person who is charged for possession of an illegal firearm, ammunition, and prohibited weapon, and that person has a pending charge for a possession of same. Now, the bill was passed in both Houses of Parliament on the 31st of July 2019 and assented by Her Excellency Paula May Weeks on the 5th of August 2019. Now, we fast forward. On the 23rd of October 2019, the Honorable Attorney General again introduced the Bail Amendment Number 2 bill, which then sought to amend Section 5 of the Bail Act, which would deny a person access to bail for 120 days who has been in possession of 2 or more firearms or prohibited weapon. This new bill somehow was defeated in Parliament on the 15th of May 2020 due to a lack of opposition support. Now, the opposition argued that there are enough laws in place, and what is needed is more judges, reform of the prison system, as well as reform of the police service. In light of the latest surge in kidnapping and murder, the government is introducing or is considering reintroducing the Bail Amendment Act in an effort to push the agenda for denying of bail for particular offences. Now, today, my guest will weigh in on this discussion. Her name is Renuka Rambhajan, attorney at law of Fortis Chamber. A bit about Renuka. She has been practicing law for a period of 17 years, having first trained with the Honorable Mr. Justice Ronnie Budu Singh and Madam Justice Gillian Lucky, who are now both Court of Appeal judges. She joined the DPP office, that's the Director of Public Prosecution Office, in 2005 and prosecuted several cases over a period of 11 years. She also practiced in the Cayman Islands as Crown Counsel and returned to Trinidad, where she assumed the role of a manager of legal services at the Children's Authority. She then entered private practice as advocate counsel, specializing in criminal and family law. She also tutors at the Hewarding Law School in trial advocacy, and she's part of the moot team. She's very experienced, having been both prosecutor and now defense counsel. So I bring her on, Renuka Rambhajan. Good morning.
Good morning, Rondell.
And how are you?
I am doing fine. Thank you for having me.
Thank you for joining us. And as I always tell my guests who are tutors, that their students are listening fervently. So
just what I need, a little more pressure.
Of course. So let's get into the discussion. As we would have discussed from the headlines, are more bail laws enough to solve crime? Now let's start from the inception. What is bail?
Well, bail is the right to access the ability to come out of court with conditions attached so that you will attend court. The court is making sure that you are attending the court, that you are attending the hearing so that your matter would be dealt with, but you're not in a prison or in a cell waiting for your matter to be called. In other words, bail is the right for you to access your right to justice without being placed in a cell while you await the outcome of your matter.
Now, what type of offences are bailable?
Well, it's easier for me to say the types of offences that are not bailable.
Yes.
Murder, treason, and piracy. Those are the 3 offences you cannot get bail for. Everything else is bailable.
However, a lot of times persons are denied bail. Now tell us, why are persons often denied bail?
Well, as it stands right now, there are certain conditions the court will have to consider when an application for bail is made. One such consideration would be whether or not the person has previous convictions of a similar nature, whether or not they have convictions similar to the type of offense they have committed, or it's related to a particular type of offense. You would have spoken about firearm offenses. That would be one where bail is denied very quickly. Your antecedents, your character, whether or not you have ties to the country where you are at, your family ties, social ties, all of these things are considered. If it is you, the court is of the view that they are not sure you're going to attend court, then bail would be denied. So we have to understand that bail is not punitive. You are not being punished because you are charged. Yeah. A person is innocent until proven guilty.
Yes.
So if I get charged for an offense, I would want to go before the court and say, I am innocent until proven guilty, and I would like an opportunity to stay in my home and attend court, and therefore I would want to access bail.
Now, the first point of charge, or actually first point of the court, is the summary court. That's actually the magistrate's court.
Correct.
Where you are a convict, not a convict rather, but someone who's charged.
Correct.
Will go before the magistrate's court. Once that person is denied bail in the magistrate's court, can they apply for bail in the High Court?
Absolutely. There is a right. Once it is a magistrate denies you bail, a magistrate is supposed to tell you you have the right to apply to a judge in chambers. So you then file an application before a judge, and the matter would be listed, and the judge would hear your application, and sometimes you will be granted bail, sometimes you would not.
Now, let's fast forward to present. We've seen that, as I stated in my opening, that there would have been a first Bail Amendment Act.
Yes.
Now, could you explain in terms of what is the denial of bail for 120 days?
Okay, so initially what happened is the amendment was proposed to deal specifically with the number of firearm offenses that were taking place, the number of murders that were being committed with the use of firearms. So to deal with that as quickly as possible, the amendment was proposed that if you are held with a firearm, you would not be entitled to make an application for bail for 120 days. And during that 120 days, the state is supposed to prepare your case so that if it does not start in 120 days, then you can make the bail application. So in law, we say prima facie, there is no right to bail if you are charged with a firearm offense under the Bail Amendment Act for 120 days, regardless of the circumstances within which you were found with that firearm.
No, that particular piece of legislation was passed, not so?
It was.
But it was passed with respect to persons who would have had pending conviction or pending matters.
Correct.
Of a similar nature.
Correct.
Now, the Bail Amendment number 2, which would have been reintroduced to Parliament. Now, tell us exactly why did that fail?
Well, from my reading of what happened in Parliament and so, I think the issue was the introduction of the use of automatic rifles. And there was an amendment where if a person, and I believe the Commissioner of Police would have made reference to it, if a person is found with heavy artillery, automatic rifle, not a handgun, something that we would not ordinarily find in Trinidad and Tobago, that person would be considered a threat to national security. And as a consequence, they would be denied bail because of the type of firearm that they had.
But then also I was reading from the opposition's point of view, was that even though a person, well, at least prior, you would have needed a pending charge. But now, even if you're a first-time offender, you are now denied bail.
Correct.
Now, the dissenting view was such that, well, you are against persons' human rights.
Correct.
And tell us, why is it that that view would have been such a prevalent view by persons opposing?
Because the right to access to justice and the right to due process of law is constitutionally guaranteed. You would be familiar that recently there was an application made before Madam Justice Joan Charles in a matter called Akili Charles, where it is the constitutionality of the Bail Act was challenged. More specifically, it was challenged in relation to persons charged with murder and whether or not they could be entitled to bail. The Law Association intervened into that matter and had very strong views as well, which suggested that there needs to be reconsideration of the bail position. In other words, this idea that if a person is charged, we need to lock them up to protect society is actually a step backwards in terms of jurisprudence and human rights. Because you have the right to bail in most circumstances, you should not have that right arbitrarily removed.
And now, usually pieces of legislation will state that because this is inconsistent with Section 4 and 5 of the Constitution, you need a special majority.
Correct.
Do you think that bail laws, do you think that the more they introduce bail laws, do you think that bail laws are needed? Isn't it already legislation?
It is. You see, because when people study the amendments, I would like to say that sometimes the second verse is same as the first, because when you look at the amendment, what they are proposing is already in the Bail Act. For example, bail is denied to a person who has committed an offense of a similar nature within the last 10 years. One of those offenses listed in the schedule to the Bail Act is possession of a firearm as well as possession of an imitation firearm. So what are we really introducing in the amendment? Something that is already there. And sometimes we need to be careful that when we legislate and we look at a narrative where we are telling the public, we need to lock them up, that goes against the grain of a person being innocent until proven guilty. So we need to be careful sometimes whether or not we are legislating for public policy, public popularity, or if we are legislating in accordance with the rights of the individual. And
we have seen where particularly in light of the kidnapping of Andrea Barrett.
Correct.
Sorry that this matter keep on presenting itself, but I think this would have propelled the Attorney General to now call for the persons opposing to reintroduce the Bail Amendment Act, and still one cannot understand what exactly are we reintroducing?
Correct. You see, is it that we are reactive or are we proactive? When you're looking at your legislative agenda, one would assume that you have a target or a goal. If it is your goal is to deal with bail holistically, then you have to look at it more than just in this piecemeal fashion. It cannot just be that we are making amendments when it comes to possession of firearms and ammunition. It cannot be that we are making amendments with this 120 days and sunset clause and we're doing things in a piecemeal fashion. We need to have a proper study done of the conditions of the remand yard, for example. If a person is charged, let me give you an example. Right. If a person is in a vehicle, if I am traveling with my friends, and one of my friends pick up somebody who they know but I don't know, and he or she has a firearm on them, and the police stop us in a roadblock, all of us are going to get charged.
Correct. With
the introduction of this bail amendment number 2, every single one of us will be denied bail for 120 days, despite the fact that I had no knowledge that this gentleman had a gun on him. Is that fair to me? You understand? So if I'm innocent until proven guilty, I am forced to stay in a cell in remand yard for 120 days. And let us be real, jail is not a nice place. When you look at the Court of Appeal decision in Walter Bonio, there was a reference made to a judgment from Madam Justice Carol Gobin, where she went to the prison and she described the conditions of remand yard as beyond inhumane. These are people we're dealing with. Yes, society would want to look at them and say, you're charged and you should be lock you up and throw away the key.
Yeah.
But that is not the way the law operates. The law must be fair, it must be unemotional, and it must be specific and clear.
And like, for instance, let's go to the violent sexual offenses.
Correct.
Isn't that already, the court has the jurisdiction to deny bail?
Correct, in certain circumstances. So sexual offenses are very emotive offenses because people want to lash out. It leaves a very bitter taste in the mouth of the population. So people would be like, no, lock them up and throw away the key. But sometimes you need to understand that not every allegation will lead to a conviction. If I deny someone bail until the end of their matter, how many years are they going to be in remand yard? A sexual offense matter in Trinidad and Tobago that starts in the magistrate's court, and if the person is committed to stand trial in the high court, takes up to between 5 to 7 years before a trial is done.
Yeah.
Murder is even longer. So that means if an innocent man is in prison, denied bail, he has to wait 7 or 8 years before he can provide his defense and then walk out of the hall of justice, having been found not guilty.
So therefore, how do we sensitize the public in terms of the law and the legal process? Or is it that we are now desensitized to the law because of crime?
Well, the funny thing is, I think that's a double-barrel question. I think we have been desensitized. I think the narrative from the politicians, the narrative on social media has been almost retributive. And that is a move away from the rehabilitative and reformative arms of justice. And we need to get back to rehabilitation and reform. Not every bandit is going to remain a bandit. Not every rapist is going to remain a rapist. Some of them can be reformed. Every murderer who comes back out can be given an opportunity to rebuild his life, to become a contributing member of society. And I don't want people to say that I'm a bleeding heart. And I was a prosecutor for 11 years. So, to put it simply, I locked them up for 11 years. Now I'm a defense attorney. I'm letting them out. And a
lot of persons will say, well, how can you do that? Is that conscionable?
Of course it is, because I'll tell you why. It took a lot of maturity for me to develop and move from being a prosecutor to a defense attorney. And the thing that governed my process is justice is not for only one side. The streams of justice flow both ways. So the same way that a person is charged and might be innocent and is entitled to a full and proper defense, a victim who has suffered crime is also entitled to have his voice heard to the best of the prosecutor's ability. So as counsel, if you do your best and you stand on the ethical ground of doing your best, it does not matter what side of the bench you stand on. That's my personal view.
All right. And let's go to the prosecutors. Now, a lot of times the prosecutors would challenge bail.
Correct.
Right? Do you think that this is because of their lack of preparation?
Not at all. I did bail quite a few times when I was the prosecutor. In fact, several colleagues of mine have confessed to me when they saw me as the bail prosecutor, they'd shake their head and be like, we're not getting through today. You would have a bail officer, a police officer, who would have all of the applications that the judge is going to look at. And they are given an opportunity to investigate and prepare reports for the prosecutor. That investigation would usually be, where's the person living? How long have they lived there? Do they have ties to any criminal elements in the community? Where do they work? How long have they worked there? And you present essentially a report to the judge that says, I do not think this person is a flight risk. The purpose of bail is to ensure your attendance at court. That's it. It is not punitive. It is not rehabilitative. It is not restorative. It is simply come to court to do your matter. That's it.
And it doesn't mean that because you are granted bail, it means that you're innocent.
Of course not.
Or because you are granted bail, it means that the court doesn't look at society's ills or the bleeding heart of society.
Correct. So like a magistrate or a judge who's considering bail under the Bail Act, he would have to look at the character and antecedents. He will have to look at the number of offenses. He also has to look at the strength of the prosecution's case. Because if the case is strong, the propensity for the person to flee is higher. So those are considerations that the prosecutor would put before the judge, and then the ultimate arbiter would be the judge who would decide whether bail is granted or not.
And then, of course, if bail is refused, can you appeal? Well, if bail is refused in the High Court, can you appeal?
Yes, you can appeal to the Court of Appeal and make an application. Of course, you have to support your application by affidavits and so on, show where it is the judge or the magistrate may have misdirected themselves on the law. There haven't been many appeals on bail to the Court of Appeal as far as I know.
Right, so going back to the question, what is needed to solve crime rather than introducing bail laws?
Wow, that is such a heavy question for me to answer, and I don't even know if I have the proper remit to answer. But as a citizen of Trinidad and Tobago who loves my country, crime needs to be dealt with, and it cannot be dealt with in this cowboy fashion. It cannot be a gun-slinging republic. We cannot become a police state. So we need to be careful. I keep saying we need to be careful of the narrative. Right now we see a lot of statements being made by the Commissioner of Police, statements made by the Attorney General, statements made by attorneys. Everybody has a voice. And that is good, because the voice means that we're going to have different suggestions. We need to sit down and have a stakeholders conference with all of the parties: prison, police, the Attorney General, the Law Association, the Defense Bar, the DPP's office, and try and come up with realistic solutions. One of the issues I have personally found with the passage of legislation is that it is very reactive. as you would have raised the Andrea Barrett issue, I was a temporary senator in Parliament when the argument on the evidence amendment bill was proposed prior to Andrea Barrett's death. The argument at that point in time, which I made, was we are not ready to implement the things that are in the legislative agenda. In the Evidence Amendment Act, there are things that suggest the use of CCTV footage for identification purposes. We don't have that in Trinidad and Tobago just yet. We can use CCTV footage, it is admissible, but for identification purposes, identification by photographs, simple things like we don't have paper to print photos for a trial, how the police going to have access to it? So we need to really sit and look at the realistic and practical challenges faced by all of the stakeholders and see how we can hold hands with each other to try and solve the issue. Passing legislation creates an additional burden on the police, it creates an additional burden on the DPP's office and the judiciary. I don't think all three of those overburdened state enterprises need any more pressure at this point in time with a crime rate that is escalating.
Now, I am thinking even with the passage of continuous legislation, how does the police service deal with continuous training? Do they even have the budget or do they even have the resources to train police officers when legislation are passed that affects the police service?
Correct.
The Evidence Amendment Bill is a big piece of legislation that I'm not even sure if the police service has the tools.
Correct,
right?
correct.
And therefore it frustrates the entire system.
Correct.
So are we dealing with things, as we said, we are dealing with things emotional?
Yes.
But how, in terms of, okay, let's look at the virtual hearings.
Yes.
We were discussing now where courts are closed for this period in June unless matters are urgent. How does this affect bail?
Well, the new practice direction that was issued by the Honorable Chief Justice defined what an urgent hearing would be. So essentially what happened in the regulations, courts are closed, all virtual hearings are suspended, except for matters that are deemed urgent by the registrar of the court. So you have to make an application to the registrar and show that the matter is urgent, and then it would be listed for hearing, virtually that is. The matters that have been defined as urgent would be custody, maintenance, charge cases. Bail is not listed, and that is very, very concerning. In fact, I believe Michael Ruplal, who is the president of the Association of Southern Lawyers, wrote and asked for clarity on the issue of bail, because in my respectful view, bail should be considered an urgent application.
And in terms of getting a response to that, we are still awaiting a response?
I believe so. I haven't seen anything from the association yet.
So in terms of criminal practitioners like yourself, how are you able to now circumvent that situation whereby bail is not part of the practice directions?
Right. How do I do it?
Yeah.
I file and I say a prayer and hope that somebody processes it, because right now I do have applications for bail that I want to file, and I am waiting for some guidance as to what's happening, but I'm filing my documents and I'm hopeful there will be some clarity in the process soon. And
let's go back to the firearm offenses.
Sure.
The Firearm Offences Act would have stated prohibited weapons.
Correct.
And of course, there would have been the amendment which broadened the prohibited weapons definition.
Yes.
Has that been effective, though, in terms of...
I haven't seen any statistics or any information, really, to suggest that such a draconian move and definition has been helpful. A prohibited weapon under the Summary Courts Act can be an ice pick. So if you are including prohibited weapons under the Second Amendment Bail Act, you might find persons who might have a ice pick in their door because they work taxi and they're afraid somebody robbed them, getting imprisoned for 120 days before they could access bail. That would not be right.
And then we have the sunset clause. Just explain to us what exactly are those sunset clauses when it comes to these amendments.
Well, because, and this is the funny thing, because these amendments are so draconian, there's a recognition by the legislators that it can only exist for a short period of time. So they would usually provide it, pass it through the houses, and then say it will only apply for a period of 1 year or 2 years or 3 years, and then be subject to renewal. And the reason for that is most of the bail amendments that have been proposed are contrary to your constitution. So it requires a special majority in the House. So once you are interfering with persons' constitutional right to liberty, they will add a sunset clause so that it automatically comes up for review.
And is that necessary though? Is that part of the Constitution?
I think it is, because if it is, like I said, if we are passing legislation in a reactionary way, this Andrea Barrett thing would have caused a lot of discussion, good discussion, to come out. But we see that it is dying down. So sometimes things are cyclical. So right now, the issue of bail might be paramount in persons' minds. But about 6 or 7 weeks ago, gender-based violence was on everybody's mind.
Yes.
So sometimes the life itself causes you to review decisions you might have made a few weeks ago. Circumstances would change. Public pressure might cause you to look at the legislation again. So those are things that would require you to review the legislation.
And it is hope that at least persons who are listening out there would understand the attorney's plight as well, right, in terms of protecting their client's interests.
Correct.
Right, rather than just defending persons for defending sake, because it's part of the legal professional act.
Correct. Everybody is entitled to proper representation, regardless of who they are. I sit as an attorney. I do not sit as judge or jury. That is not my role and function, as is yours.
Yes.
So our duty, we took an oath. Our duty is to represent our client to the best of our ability and to seek their interests. And that's what we have to do.
And that's why sometimes the lawyers will be like Marmite, either you love us or hate us. But we are there.
Agreed.
But we are there to do a job that is part of our professional obligation.
Yes.
And sometimes I think probably proper public education.
Correct.
Is important, and that's where our law association comes in as well.
Correct. And persons like your good self,
Yes.
and I want to commend you on the work that you're doing, because it's starting the conversation in the right place. It is not reactive. It is proactive. We're looking at views, we're hearing different opinions, and we're putting things together in a way to cause the discussion to be fruitful. And I congratulate you on that.
Thank you so much, Renuka. Any closing statements?
Other than to say that I think that many people misinterpret what bail is. And education is always powerful. Knowledge is always powerful. You don't need to read a law book. You don't need to go to a law library and troll through the books as we used to do.
Yes.
You could go on Google and put in how do I access bail and read about your rights. Every single person is entitled to bail, and an application can be granted or it can fail. Your purpose, though, is to ensure you have the right access to justice.
And access to justice is most important, because as they say, justice delayed
is justice denied.
Correct. Thank you so much, Renuka.
Thank you for having me.
And of course, you are free to come again.
Thank you. It was a nice conversation.
Thank you. You have been watching Strictly Legal on WESN Content Capital. You heard us. You had my guest. I had my guest, Ms. Renuka Rambhajan, attorney at law. Thank you for watching and see you next time. God bless.